Vicar Moore.
First, I want to thank Mike for inviting me. It's a delight to be here. I like this paper, and I learned from it, and I can never ask for any more when I read a paper. And I think there are a couple of reasons why I liked and learned from it. First, it's a very elegant and erudite essay, and I think it helpfully sheds light on many important conceptual and pragmatic aspects of originalism in all its forms and nuanced iterations. Its execution is graceful, its prose lively. I profited from reading it. But the other reason I think I learned from it and I enjoyed it is because, I'm a bit on the outside looking in compared to some of the folks in this room. I don't know that I consider myself a party crasher the way Heidi described earlier, but I'm somebody who does originalism, but doesn't in a lot of my substantive scholarship, but I don't spend a lot of time thinking about why I'm doing it. A few moments ago I was trying to figure out how to describe it. It's kind of similar to, for me, originalism is similar to watching Desperate Housewives. I do it, but I don't talk about it. So I think that's helpful for me because it gives me a perspective that may be useful to some people who are really immersed in the midst of this. And I think some of that may come through in my reactions to some of the things that Will says. On balance, I think the piece is extremely useful for those who already kind of embrace some variant of originalism as the centerpiece of their interpretive methodology. I think it offers a little bit less to people, and I'm not in this camp, but I think it offers a little bit less to people who are deeply skeptical of originalism in its modern practice, especially at the U.S. Supreme Court. The first comment I guess I'd like to make is that no one can, or I think does, attack all originalism all the time. Maybe I heard some of that from Heidi earlier, but almost every kind of substantive constitutional jurist and analyst I know makes use of originalist arguments quite frequently. To paraphrase Jack Kennedy, or maybe Jack Balkin these days, ich bin ein Originalist, and it's I'm not afraid to say that, even though I'm part of a very progressive University of California faculty. I did a Westlaw search, and I found that from, I think it was 75 to 80, William Brennan cited the Federalist more frequently than William Rehnquist. I think in some ways Will undersells the influence of originalism, at least as a facial matter, at least in terms of the way the court purports to explain its results, when he says cases like Heller and Apprendi are the aberration. No, they're not the aberration. There's originalist parts of virtually every major constitutional case, especially those that aren't really located in the interstices of minute doctrine where the court says the question presented today is what we meant 4 years ago in X. But aside from those, I think originalism is all of now. Whether it's really doing the work, that's something that's going to be hard to prove or disprove. And I think this ultimately makes sense. I don't think you can interpret text without context. My brother is, I think he quipped once, and I saw this on Family Guy later, and I don't know if there was a connection, but without context, the right to keep and bear arms could be understood to be the right to possess the forelimbs of grizzlies and Kodiaks. What does it mean unless we understand what those words in some historical setting meant? So I think then the relevant questions become, okay, what kind of context, at what level of generality do we understand the context, what other factors might outweigh even a clear contextual consensus, etc. And as Will shows, there's no shortage of answers to those questions in the Academy. So that brings me, I guess, to the criticisms that Will tries to put on the table and then deflect, both of the Academy and of the judiciary. Let me briefly say about the Academy, I don't have as much to react to there, in part because I don't know that what we do matters that much. It's like criticizing me for what I had for breakfast this morning. You could do it, but I don't know why it's really that important. The one thing I guess I'll say is, to the extent that there are conceptual originalists who really feel normatively, as opposed to just positively inclined to implement the original meaning without regard to any consequences, I think that's hard to sell. I can't imagine anybody is really immune from some consequentialist kind of reasoning. I asked my con law students at the beginning of the semester, hey, can you give me an example of something where you know it's unconstitutional under the agreed upon meaning, but we'd still want to do it again anyway? And this past spring, somebody gave me one that I kind of liked. It was, we all agree, as Mike Paulson said, that the 35-year age requirement for the presidency is one of the clearest examples as to coherent meaning or agreed upon meaning. But what if there were some virus that killed all people over 30? Or all people over early 30s, would we say that you can't elect a president, that you have to change the Constitution to have a presidency? I don't think so, but we can talk about that. I guess most generally, and I'll just make a few points and then shut up, I'm not sure I sensed that Will's paper grapples with what I take to be the most trenchant criticisms of originalism in practice by the judiciary from my vantage point. Let me mention a few. Some of them relate to what the academics are doing, even though I think they're criticisms of judges, not academics. One criticism is, look, this stuff is just so complex. The judges can't be doing this. It's bad enough that they're trying to be historians, which they're not. But then you're posing all these really nuanced historical questions about who and when and how. There's just no way they can do it competently. It's akin to what they do with statistics. I'm just reading some papers about how bad judges are with dealing with the probative value of DNA evidence in criminal cases, and when they send cases to juries and when they don't. And it's just amazing how Article III judges would fail freshman statistics classes in college. And the idea would be similar here too, that it's just beyond the kin of a group of people who don't really focus on it on a daily basis for a living. And then the question becomes, well, is well-intentioned but poorly executed originalism, is that worse than no originalism? I think you can make an argument that it is. It's not as accessible or accessible within the four corners of the opinion the way other kinds of judicial reasoning that's more pragmatic might be. It creates kind of a veer of historical objectivity and answers to questions that don't really have answers, but rather just confines. And it may kind of, I think, bury some of the key judgments that are being made and make it harder for people to unearth them and deal with them. A related criticism, I think, is that justices will use originalist techniques in ways that are very inconsistent with each other. They'll use different levels of generality at which to assess the history in different cases. They'll make different analytic moves in different cases that don't seem very methodologically similar. That's a hard criticism to prove because it requires a look at a ton of cases. And part of the appeal of Will's thesis is that it's pitched in such a general way that it doesn't really admit of disassembly, because he doesn't want to get into all the different variants of originalism and which one is the right one and the like. But I guess Will identifies as the problem the divergence between what judges are doing and what our academics are doing. I don't see that as the big criticism. It's not the divergence. Indeed, I'm not sure how you can diverge from originalism unless you agree on which kind of originalism you're diverging from. The originalism tent, as Mike said yesterday, is so big that I'm not sure what we're talking about diverging from. To me, the question is whether there's internal consistency within originalist reasoning. And most troubling, the possibility that people use originalism on the court in an inconsistent way, not by accident or by incompetence, but by design to reach more truly result-oriented outcomes of the worst consequentialist kind. Indeed, it's kind of ironic that the most common form of consequential argument that Will says is made to support originalism that confines judges is also kind of the basis for the most powerful critique, that they're not using it in a coherent way. They're using it precisely to be free from confines so they can decide cases however they want. 2 minutes, okay. Will's response to that rests largely on a reliance on stare decisis and the limits that litigation creates because the parties have framed issues in a particular way. let me say just a word about the litigation framing. One of the things I do, I write the volumes for Wright and Miller that deal with the certiorari process and the like, and I don't think there's really much constraints on what the courts do. And if you're not sold on that, then just read Citizens United, and then come back and talk to me about how the courts are kind of limited by how the parties are framing things, and that's kind of what's keeping everything in check. So let's go then now to stare decisis. I just don't think that works for me for a few reasons. First, stare decisis is open to the same criticism that I just leveled towards originalism. Namely, there's no coherence there, and that it's itself a vessel that people use to reach particular results they want to in particular cases. So when you push the bubble under the rug, if you push the result orientation bubble from originalism to stare decisis, that doesn't move me because you still got to deal with it. And certainly there's no, as Will even admits, there's no explanation by the originalist justices about why sometimes stare decisis prevails and why it doesn't. And I discern no obvious pattern in their use of stare decisis to overrule some non-originalist decisions they don't like, but to preserve others that they don't like. But let me just close by mentioning a few really kind of more prominent examples. I'm just going to use Scalia because he is the most prominent originalist, and it's hard to talk about this without making the context a little bit more concrete. Why does stare decisis win in Union Gas, and we keep an arguably non-originalist 11th Amendment because the states might not have adopted the 17th Amendment otherwise? But when it comes to women's rights and the ERA movement, which might have been influenced by the cases that he doesn't like from the 70s, he's not willing to respect that. Why? It pained me to see him ridicule the lawyer in the McDonald Second Amendment case, the privilege and immunities argument, saying, "Why, unless you want to be a law professor, why are you talking to me about originalism?" Other than a fear that privilege and immunities would open the door to more rights claims, I'm not sure why there was a reliance interest there that would justify maintaining stare decisis. Worse than that. There are so many cases in which just one more, just that he won't even engage originalism that other justices advanced. Two quick examples. In City of Bernie, the Section 5 case that Mike talked about yesterday, Kennedy writes an opinion and makes an originalist argument. Scalia concurs in the rest of the opinion, won't concur in that part alone, and never explains why the decision is nonetheless right. There was no stare decisis constraint in Bernie. It's not like Bernie was dictated by past cases. And then there are other areas where they don't even talk originalism altogether, and I'll just mention race-based affirmative action. I mean, show me where stare decisis compels the colorblind Constitution, or they've defended it Scalia's defended it in originalist terms. It's that kind of seeming selectivity that I think is the bigger kind of criticism that people make. So, sorry.
Okay. I can't respond to them all, but as to originalism being too complex for judges, I guess I just don't think that's right. I just think that in almost all cases that come up, the originalist answers are usually pretty easy, and the bigger question is whether or not you care. Or the questions that are hard are not the historical ones, but are actually the theoretical ones. So in Heller, the big conceptual move that divides the majority from the dissent is, what do you do when people enact a clause for a particular reason, but they believe themselves to be enacting a right that sort of pre-exists the Constitution and that has a scope outside that reason? And then, do you limit the right by the purpose, or do you instead treat the right as a real thing? Like, what would you do if the Takings Clause had a preface that said, in order to stop the confiscation of horses for military purposes, the right to private property, shall be protected? Would you limit the right to private property to horses, or would you say actually it's a whole right, it applies to all sorts of things, they just had it for one particular reason? And I think those are much more likely to be the hard questions in originalist cases. This may be an empirical question. We may just have to look at the range of originalist cases and figure out whether they're hard or easy. As to inconsistency, I guess it's true that I don't try to defend judges who are sort of internally inconsistent and especially on a results-based or intentional way. I do think that's its own problem. So maybe it's I take it as a good thing that you buy that the divergence between theory and practice is not a problem. I'm glad we've agreed on that, and then maybe I should just bite off the next problem, which is what to do about what to do about judicial inconsistency and judicial willfulness. I think scholars actually do provide a real constraint to the extent that they can spot, highlight, and get people to care about inconsistencies. I think scholars have to be careful when they do that because it's too easy to cry wolf. There are a lot of things that people accuse of being inconsistent that aren't so inconsistent. So we'll just use one example, which is Citizens United. That's a case where, when the case comes to the court on mandatory jurisdiction, in its opening brief, one of the parties the petitioners asked the court, Citizens United asked the court to overrule Austin versus McConnell. Overruling that case has the necessary implication of, Austin versus Michigan. Overruling that case has the necessary consequence of overruling McConnell. As everybody seems to understand and concede, there's no way to overrule one and not the other. So the court asked the natural question, asked the parties to brief what to do about the second case. That doesn't seem like a strange or even a strained judicial reach. That just seems like taking the case as the parties presented to them. Maybe it is, maybe it isn't, but that's the kind of question we should have to cash out.